This is a current trends case brief of a criminal case which deals with the application of the Ontario Disability Support Act. The citation is Ontario Disability Support Program v. KVD 2014 ONSBT 1837. Facts. The appellant is a 50-year-old male who has chronic depression and frequent headaches. He claimed that he finds it hard to function socially and occupationally. Therefore, he applied for income support as a person with disability. According to Section 4, Subsection 1 of the 1997 Ontario Disability Support Program Act, in order to be considered a person with a disability, the person must meet the following requirements. The person has a substantial physical or mental impairment that is continuous or recurrent and expected to last 1 year or more. The direct and cumulative effect of the impairment on the person's ability to attend to his or her personal care, function in the community, and function in a workplace results in a substantial restriction in one or more of these activities of daily living, and the impairment and its likely duration and the restriction in the person's activities of daily living have been verified by a person with the prescribed qualifications. On the basis of Section 4 of the Ontario Disability Support Program Act, the Director of the Ontario Disability Support Program determined that the impairments suffered by the appellant were not substantial, and that there were no substantial restrictions in one or more of the activities of daily living listed in the same section. The appellant disagreed with the Director's May 31, 2013 decision and appealed to the Social Benefits Tribunal. The Tribunal was not satisfied that at the time of the Director's decision the appellant's impairments were substantial. Medical reports from 1985 to 2008 showed that the appellant accessed mental health treatment from time to time. These medical reports indicated that he had attended 7 counseling sessions from March 2012 to July 2012. Even though this provided a good background of the appellant, there was no evidence of the substantiality of the appellant's impairment. The family doctor rated the appellant as having only minimal or no symptoms or signs on the intellectual and emotional wellness scale. The family doctor at the time of application indicated the only treatment as Cipralex, 20 mg OD. Pharmacy reports indicate that level of dosage remained unchanged to the date of the Director's decision. The appellant indicated that he was unable to work because of his bad energy levels and little motivation. After further prompting, he indicated that he lacked patience and lost his temper. The appellant had also pointed out that his last job as a cleaner in a bakery department had ended because of a problem with his manager and because his relationship with someone there ended badly. The issue here is, should the appellant's appeal be accepted and should he be allowed to get income support as a person with disability? The Social Benefits Tribunal denied the appeal and affirmed the decision of the Director, as the appellant did not meet all requirements to be considered a person with disability. The Ontario Court of Appeal had dealt with a similar issue in 2002, which was concerned with the appropriate determination of substantial impairment within the meaning of Section 4, Subsection 1 of the Act and Gravy v. Director of Ontario Disability Support Program, 2002. The court decided that compared to its predecessor within the same federal legislation, it would appear that the definition of person with a disability was intended to provide assistance to persons with significant but not severe long-term functional barriers. The Court of Appeal in Crane v. Ontario Disability Support Program 2006 stated that Section 4, Subsection 1 presents 3 separate tests that require separate answers where the appellant is to establish all 3 factors. The court also said that evidence relevant to the factors in paragraph A and B of Section 4, Subsection 1 may overlap because the determination of whether an impairment is substantial or not depends on the person's ability to function in the domains of personal care, community, and workplace. Having determined that the appellant's impairments were not substantial, there was no need for the court to go on and consider the nature of the restrictions in the appellant's activities of daily living, as it is necessary that both thresholds be met in order to meet the test for a person with a disability. The determination of whether a person is a person with a disability or not is based on Section 4, Subsection 1 of the 1997 Ontario Disability Support Program Act. All 3 requirements under this Act must be met in order for the person to be considered as a person with a disability. The decision made was a stare decisis. It was made based on decisions from previous cases. I believe that the court made the right decision because the decision was consistent with not only similar cases within the same federal legislation, but also Section 4 of the Ontario Disability Support Program Act. Question: do you believe that Section 4, Subsection 1 of the 1997 Ontario Disability Support Program Act should be reinterpreted?